My name is Anil Changaroth. Welcome to our series of what's called the RHTLaw ASEAN Plus mid-year uh, case law update on the construction industry. Right. This is the third in our series. We started the first in Singapore 3 weeks ago, and we had the second in Korea 2 weeks ago, and today we are in Indonesia. The idea is very simple and straightforward in the sense that the country that's speaking will talk about 2 or 3 of the critical issues in the construction industry that they have faced in the last year. All right. When we did it in Singapore, we spoke about 2 case law. When we were in Korea, we spoke about legislative changes in the workplace safety. And today we've got an exciting talk by Indonesia. 2 of their speakers they will introduce themselves very briefly, and they will speak for about 25 minutes or so on what's happening on 1 or 2 aspects of what's happening in Indonesia. We will then, after they finish their part, we will then go and have Vietnam, Cambodia, Singapore, and then Korea speak for 5 minutes about what on those particular topics that the Indonesian team has brings on board, right? What is happening in our own jurisdictions, right? So by the end of that part, where the presentation is done and the discussion from each of us are done, you get an idea of, on the specific topic for today, what the region is facing and how the region deals with that, right? And if time permits, before 4 o'clock, before we wrap up, we will have a Q&A if there are questions are raised, okay? And with that, I'd like to pass the first part over to Adi, who'll just give a quick brief introduction of his firm and the team that's going to be speaking, and then we'll take it from there. All right, yeah. Adi, and I pin you, sir. Let's go.
Yeah, thank you, Anil. Sorry, let me just. Yeah,
I will pin Astro as well for your brief introduction. Then I'll take him off.
Okay, sure. Hi, good afternoon, everyone. Maybe just a brief introduction, as mentioned by Anil. My name is Adi. I'm from GHP. I'm a partner from GHP Law Indonesia, and I think today we'll be speaking. So Asto, our senior associate, and I will be speaking on 2 aspects on Indonesian construction law, which are the requirement for building failure, liability for due to building failure, as well as the tender requirement under construction law. Yeah, I think maybe it's just a little bit of disclaimer. I understand that in Singapore, the last 2 weeks, when Anil and Shafiq presented on the Singapore law, the topic raised was was based on the case law. However, as Indonesia, as we are in Indonesia, we don't have a case law. We don't have access to court, or we don't have easy access to court decisions, and our court database, online database, only provides the parties and the status of the dispute and the decisions, or the claims, or the rebuttals are not readily available. So in any case, yeah, as a civil law country, we also don't the court are not bound by previous court decisions. It may be official, but it does not bound a future court decision to follow the same approach as the previous court. So I think for this presentation, we will speak on an implementation of the construction law, rather than another case law like in other jurisdictions. Asto, do you want to? I think you can introduce yourself when you will present about your topics. I think Anil, if they're okay, I'll just start with the first topic.
Yeah. So hi everyone. Good afternoon. My name is Asto, and I'm a senior associate of GHP Law of Indonesia. And in the past 2 years, I've been assisting our ADI on the construction um, sectors that has been handled by our firm. Thus, currently I am assisting also ADI in this presentation. Yeah.
Just okay, so I think we'll just I'm mindful of the time. I think we'll just start with the presentation. So I'll be speaking on the first part on the building failure, and then Asto will continue with the tender requirement for this. So on the building failure, I think the reason why we chose this subject is because this requirement, although it's not completely new, this has been kind of touched in the previous construction law and kind of reintroduced again in the new construction law and its implementing regulation. But this requirement is often overlooked by contractors and project owners. As you may be aware, typically contractors, in terms of liability or warranty, they rely on the specific provisions under the contract, and they kind of agree and cap their liability to that liability period, which has been agreed under the contract. Typically, it's 1 year or 3 years, depending on the complexity of the project. So I think to start the discussion, I think we'll go into the definition of the building failure under the Indonesian construction law. The definition of a building failure under the construction law is a condition of a building collapsing and or malfunction after the final handover of the construction services. So I think based on this definition, I think we can agree that this is a very broad definition. I think it covers, as the definition suggests, a building collapse or malfunction after the final. So I think building collapse is clear. I think it's much more easy to prove, but malfunction after the final handover is somehow a bit ambiguous, and it can be interpreted as a building not being able to operate or not meeting the specification as agreed under the design documents or even under the contract, which may overlap with the defects or warranty of defects under the agreed under the construction contract. Now, the law specifically, so unlike the warranty period or defects notification period, which we commonly see in the contract, which are open to be negotiated and agreed by the parties under construction law, the law regulates the liability period for building failure. Under the implementation of the construction law, it is mentioned that the liability of the for the building failure is tied to the lifespan of the construction based on its design document, but it is capped at 10 years. So for example, if we're designing a building and the design lifespan is 30 years, then the contractor will be liable for building failure for maximum of 10 years, as it is capped to 10 years under the law. But still, I think 10 years is still significantly longer than what is usually agreed. Usually under the construction contract, because I think typically, as I mentioned, it's somewhere around between 1 year or 3 years after taking over, and following that 3 years, usually the contractor does not want to be will deem that the contract is over, it's completed, and there is no longer liability from the contractor side. But so this is the reason why it's commonly overlooked. When we review a construction contract, especially if it is drafted by or prepared by foreign contractors or contractors that is based in outside of Indonesia, they don't have this specific provision on building failure, and they assume that the warranty period is sufficient to cover the warranty period under the contract is their only liability in terms of warranty. So after that, they're not liable anymore. So the law also says that if after the 10 years period is elapsed, then the liability will shift to the service user. Although I think in reality, in practice, it's not always the contractors that is liable for building failure. We do see some instances, although there is no court decision yet, as I mentioned, there's no, we are not able to find a court decision, but we do see in the news, instances of building failure, which resulted in investigation by police, by a special task force, if it's a large enough scale of a project, which was not actually the fault of the contractor. For example, the building was supposed to be for residential use. It was not intended for example, we're constructing an apartment building for let's say 7 stories, not a high-rise apartment, but it's just it's a duplex of 7 stories residential building, right? And then it was not designed for commercial, for restaurant. It was not designed for commercial use. But then the building owner decided to open up a restaurant, for example, in the top floor, which was not which the building was not designed for that, and that resulted in, for example, the building collapse. And based on the investigation, what we find in the news, that it was evident that it was not the fault of the contractor. So the liability is transferred to the person who's liable for the building failure is the surface user due to the improper use of the building. So I think what I want to emphasize here is that the building failure is not automatically the fault of the constructor. It could be the service user as well, and it may be subject to investigation by the authorities, determining who will be at fault. And this provision under the law, as the building failure liability is provided under the law, it gives a right for a third party to also make claims, to also claim for damages to the party who is responsible for the building failure. If it's decided by the authorities that it is the contractor who is at fault, then the person or the party who suffered or incurred losses or damages due to the building failure may claim for damages to that person responsible. Yes, we do have an example of a building. So there are 2 buildings and adjacent to each other. The first building is collapsed, which impact the tenants of the second buildings, and the second buildings, the tenant of the second building were actually entitled to make claims to seek for compensation from the contractor of the building A, the first building. So one thing that we also want to emphasize is that in the construction law in Indonesia have a requirements on what provisions has to be provided under the construction contract. Some of them are obvious, like for example, the parties, rights and obligation, force majeure, and some of them are much more specific to Indonesian law, like for example, the building failure. There are 2 provisions that is necessary, that has to be included in the contract. First one is the provision on building failure itself, and the second one is a guarantee of risk arising from the building failure. So there has to be an express guarantee from the contractor saying that they will be responsible for building failure if in case that happens. Now the common question that we get in relation to this building failure is whether or not parties can waive the applicability of the building failure provision or somehow limit the period. Some some would argue that because we have limited our liability to 2 years, for example, the warranty period is only 2 years under the contract, meaning that if there's anything happen following the period of 2 years, then it will be the responsibility of the service user. It's no longer the contractor's responsibility, right? But I think we have to distinguish between the contractual warranty that is agreed under the contract and the statutory warranty, such as the building failure. The contractual warranty can be agreed by the parties and stated in the contract, right? If the parties agree to 1 year warranty period after taking over, then after the 1 year after such period is expires, then contractor will usually be issued a performance certificate and say that they have completed all their obligation of the contract, and the owner release the contractor from any responsibility. But for the building failure, as it is not something that is provided under the contract, it is something that is required under the law. It cannot be waived, or it cannot be limited by contractual by way of contractual. Maybe the party can agree, for example, that if there is a building failure following the expiry of the warranty period, then who will be responsible? But the contract will only bind the parties, right? If there is a claim from a third party due to the building failure, then it will not be such agreement under the contract cannot be enforced to a third party. So the best thing that we can do in terms of building failure is to have a certain indemnification provision in place. So if there is anything happen following the expiry of the warranty period, including the building failure, then the service user, for example, if it's due to service user, then the service user will have to indemnify the contractor for whatever, for the typical indemnity provision or cost damages arising from such building failure. So I think the conclusion is that the parties to the construction contract cannot limit or waive the liability for building failure, and any provision that waives the applicability of building failure may be considered as null and void and cannot be enforced. So we have to be really careful on how to structure the clause in the contract on building failure. We can maybe put indemnification, but we cannot say that we're not the provision on building failure is not applicable to the parties, or the parties agree to waive the applicability of this provision under construction law. The third one is that we see that this is often overlooked. We see a lot of contracts that does not have the provision on building failure as required under the construction law, and this also impact the risk, and the liability of the contractor in the project. I think just to share an experience that I had previously, I think it was 2 or 3 years ago, and this is interestingly is related to a building that is to a construction of a facility. So the facility was taken over by the project owner as is condition. So the construction is not yet completed, but due to certain financial condition of the project owner, they decided to take over the building as is condition, right? And at that point of time, I think none of the parties, not the project owner nor the contractor, were aware or was aware of the building failure requirement. And as it is an incomplete construction, it was I think 2 years later, after it was taken over, there was unfortunately a structural failure in the building and resulted in some casualties. So the question and in that particular case was that who is responsible, right? The contractor has agreed to hand over the project to the project owner in as is condition. They are aware that it's not complete yet, and so should the project owner. They are also aware that it's not yet completed, and as the project owner has also some works in the adjacent adjacent facilities in the adjacent site. The structural failure of that particular construction result in the casualties of the personnel of the project owner. So yeah, I think at that point of time they've reached an agreement that it was fortunately they've able to reach an agreement that it was the responsibility of the project owner, and the personnel that was impacted has agreed to kind of sign a release saying that we've been compensated by the project owner, so we will not seek any compensation based on the law. But imagine if they decided to make a claim. I would imagine that it would still possible for the personnel to make a claim based on the construction law, right? They can either claim the project owner or the contractor, because the building has been taken over and there was a collapse or the malfunction in the building resulting in the damage to the personnel. So I think this is something that has to be, it's something that contractors and project owners has to take into account when they formulate the contract, when they identify the risk of the project, and as it may also impact the cost, the contractor's cost. For example, they have to get additional insurance, for example, and so on. Yeah, I think that's just a brief explanation on the bidding failure. And I think Asto, you can continue with the tender requirement. I think I'll continue with the slide so you can present, and I'll just share the screen.
Thank you, Paddy. So thank you, Paddy, for the introduction and the explanation on the building failure. So the second topic that we are want to discuss is that for the tender requirement under the Indonesian law. Why are we choosing this topic? The reason is that due to the current growth of the construction sector in Indonesia, and based on our experience, there are quite the interest from both domestic and international construction company to participate in the construction business sector in Indonesia. So previously, on 1999, Indonesian construction law require all the construction work to be awarded to tender. However, upon the enactment of the 2017 construction law, in order to expedite and support the growth in the construction sector in Indonesia, the Indonesian government carved out the requirement to have the tender into and limit the requirement for a tender only for construction work that are financed by the state budget or APBN, and B, the construction for public interest development. Next slide, please. The interesting part is that the current law didn't provide further explanation of the construction public construction sector. Sorry, so based on the law, public interest in the construction building that have an impact on the first one is the interest of the nation and state, and the second one is the interest of the community. Therefore, based on the public interest referred to and related to this issue also means that the construction of public work projects, for example, residential buildings, are also included in the public interest development, which in the public interest sector is classified as urban slum arrangement and land consolidation, as well as housing for low income people with rental status. So the current regulation provide that The public interest shall be consist of first one is national defense and security. Second one is public roads, toll roads, tunnels. The C one is the reservoir, dams, weirs and irrigation, harbors, airport, oil and gas, geothermal infrastructure, electricity generation, telecommunication and informatics network of the government, waste disposal and treatment sites, government or local government hospitals, public safety facilities, public cemeteries, social facilities, nature reserves and cultural heritage, government or local government office, arrangement of urban slums, and land consolidation as we referred to previously, educational infrastructure or government local government school, sports infrastructure, public markets, and public car parks. Unfortunately, unfortunately, the tender process is not regulated further for the tender process. And the interesting part is that the public sector is not immediately clear as to why, what kind of, for example, electricity generation that require to be conducted by way of tender, such as you may aware that electricity generators may be built for a private purpose, such as building purpose, and that is not intended for public. Padi, if you want to jump in.
Yeah, I think this part is yeah, as you mentioned, there's a significant change from the previous regulation, which kind of more restrictive. It says that all construction, large scale or small scale, has to be appointed through tender and is often disregarded by the party by stakeholders like Indonesia. So I think the government decided to issue a much more lenient, much more reasonable requirement, and only requiring construction works which are funded by state fund or for public interest to be conducted through a tender. So if state fund it's clear. I think it's as long as it is funded by the state, it has. So we do have a specific regulation on the procurement, government procurement, which using state fund. But for the public interest sector, there is something that is to date is still questionable, right? Whether the list that has been explained by Asto is that an exhaustive list, or whether instead of the list we should rely on the much broader description of a public interest sector under the law, which is, as long as it has an impact to the interest of the nation or state, or it has an impact on the interest of the community, that it falls into the definition of a public interest sector. So that is also still not clear. And the second part is, for example, right now we see a lot of construction of a nickel complex in Indonesia, and usually for the purpose of the nickel complex, they will construct their own power plant. The power plant, and for example the port. So there are ancillary facilities that they construct only for the purpose of their operation. It was not intended to be used by public, right? And unfortunately, the construction of ports, terminals, and electricity generation falls under the list of this public sector, public interest sector. So the question is on whether, if we construct one of this one of the construction that falls under this sector, but it was intended only for our own use, whether it is also required to be conducted through tender. Because this tender requirement, although it is important in terms of for the contractor or project owner to be able to structure, how the construction is done. Usually in Indonesia, they in large scale project, they split the EPC contracts into onshore, offshore, and it will be difficult if they've split the onshore, offshore, but the onshore has to be tendered out. So it is, so certain clarity has to be. We do need some clarity. We have on this in order for project owners and contractors to be able to structure, to decide on what structure to proceed. I think, yeah, that's that's it also. So, I think Anil, over back to you. Or
Thank you so much. Thank you, gentlemen. Let me just wait. Let me just come on. Let me see where I am. You can take your slide down, right? And let's see whether I can add me. Yes, there we are. Okay, so very interesting. You know, some of these things I will leave it to the rest of our countries to share. But you know, I like Adi, you mentioned the fact that it's a civil law system, so something that we all must understand. So like for Singapore, example, is a common law system. And you were talking about contractual provisions as opposed to what you spoke about, statutory provisions, and the time for the liability, and then the fault of others beyond just the builder as well, right? And on the tender, I thought also the fact that, you know, it is important for domestic and international works to concentrate on this, the fact that you have this law that's come into place and how the public sector should pay attention to that. So, you know, very interesting pointers that some of us may not be familiar with, or some of us may have forgotten about. But, you know, so thank you so much. What I'm going to do is that I'm going to unpin you all, including myself, and pass this on to Huong from Vietnam. Let me just add him in first. And then we will unpin. Oh, sorry, hang on a second. Where is he? Oh, sorry, I may have just dropped him out. Oh, who are you still there? Yeah, you're still there, right? Let me just pin you. There we are. All right. I will leave. Yes, we've removed all of them, and over to you, sir. Thank you.
Okay. Thank you, Edis and Esther, for your great presentations. Now I would like to share about the aspects from Vietnamese laws. Actually, under the law of Vietnam, we do have provisions governing the building incident, but however, there is no specific regulation regarding the specific responsibility of the one who make the building incident. Instead, it will depend on the results of the investigation of the authority. So they will decide who will be responsible for the building incidents after the investigation. And the second thing is that under the laws of Vietnam, the statutory periods for the buildings is from 12 to 24 months, and it's applied for the construction with have the fund from the state for the civil construction. It will be depend on the agreement of the party in the construction contract. And the third one is that for the ones who cause the buildings incidents will be responsible for compensation the breach party and the cost for remedying the incident. The fourth one is that we in Vietnam for tenders provision, it just apply for the construction which have the fund from the authority, and which more than 30% of the total investment fund, or if the construction which had the fund from the authority, the state, below 30% or 30% but above 500 billion Vietnam dong, it will go through the tender procedure. And the last one I would like to share that we do have a process of tender, and the stakeholder must strictly comply with the tender provision in Vietnam. Back to you. Anil.
Yeah. So just a quick question, Huang. When you said about the tendering, right? So there are no regulatory provisions for that. Is that what you're saying?
Sorry, can you repeat your question again?
You know, the part about the tendering, you're saying that there are no regulatory provisions for it, but it's just an understanding between that parties should just do that.
No, for the tender, it's applied to the projects which have the fund from the state. for the projects which have the fund from the state above 30% from the states, or if it's above it's below 30%, but the total investment funds is from 500 billion Vietnam dong. It's have to go through the tender procedure. For the others projects, it will subject to the decision of the party.
Okay, cool. So thank you so much for that, Huang. And we're gonna now, I'm just gonna add
Thank you.
Vishal. Where is Vishal there? Let's go, Vishal, come on. And then I'll unpin you as well. All right. Thank you, Huang. Okay, Vishal, over to you from Cambodia.
Thank you, Anil, for this. And for the case of Cambodia, we don't have the exact law or regulation that deal with the building failure, but we have a more general term, which is defect, that refers to the change from a normal or regular state of the building. So building failure could be a part of this defect. And to understand the liability of the defect, we need to look at the scope of work of each stakeholder that involves in that construction work. And in Cambodian construction law 2019, the main stakeholders may include the project designer. They are liable for the defect of design work. We have the builder or construction owner and construction owner that liable for the defect of the construction or demolition work or the construction site management work during the construction period. And we have the construction certifier who is liable for the defect of their certification work. And the construction owner, the building manager or the construction lessee, they are liable for the defect of occupancy or the defect of management of construction. And we also have the producer of construction material, equipment, and product that liable for the defect of those items. So when they look at the liability, they will look which part of this work, who is the stakeholder that caused the defect. So they will see on this part. And to those who suffer from the damage, could be entitled to compensation, of course. And for the warranty period, I look at the case of Indonesia. It is quite interesting. And in Cambodia, we also have the statutory warranty for the construction contract. So the warranty could be up to 10 years, depend on the objects of the construction contract itself. So some construction work may be 2 years, some may be 5 years, or some may be 10 years. We need to look at the exact case to determine which is the period that is applicable to those cases. But the issue is that those statutory requirements is only happen after 2019, after the new construction law. And before that, the practice of the contractual period in the contract is quite lower. So it is quite challenging for the construction sector right now. And some parties may not be aware of this warranty, and I'm glad that Indonesia raised this topic. So now they could know that there are statutory warranty period in the construction law, and they need to abide by it. If we don't abide by this, those contracts will be null and void for those agreed terms. And for case number 2 on tender requirements, we could see the law in Cambodia for the public procurement. All public procurement shall be subject to procurement procedure. And one of the main procedure for the public procurement is tender. But please note that the tender process may not be the same in all cases. We need to look at the nature of those construction projects to determine the tender process. So in Cambodia law, we could divide the process into 4 types. The first one is the general public procurement. It is subject to the law on public procurement. The second one is the public-private partnership project. So it is under the law on public-private partnership. And for the project which is funded by the development partner, it is subject to the process in the financing agreement. And for the project related to the national defense or the public security, it is subject to the approval by the Prime Minister. So this is the practice in Cambodia. So in short, there is tender requirement for public procurement, but please note that the tender is not applicable to all cases. In the case that there are exceptions under the law, they will not use tender process and they may use other process. And most of the time, this exception require the approval by the Ministry of Economic and Commerce, Economic and Finance. So I believe that's the brief update from Cambodia for these cases. Thank you.
Thank you. So what, Vishal, what we see is this: there's a similarity between all of the countries. There's a similarity between whether you're a civil law country or you're a common law system. You know, there are provisions in place to ensure, one, you know, when you're talking about issues about liabilities, whether it's contractual or whether it's statutory, but more so in your tendering aspects of what you said, there's a system in place, right? So we may take a look at it from everybody's point of view on that. So let me now just add Tim, and then Tim. So now we get to you to share with us on the position in Korea. Thank you.
Hi, Neil. Hi, everyone, and thanks for the presentations. I agree with Anil that it does seem to be quite a bit of overlap in terms of jurisdictions and different applicable legislation. So from a Korean perspective, in terms of the defect liability, the Civil Act sets out under Article 667 and 671 the regulations regarding the defect liability. So in short, under 667, statutory defect liability not only applies to completed works, but it also applies to the parts of works that were finalized before the completion of the entire works. And then under Article 671, the defect liability period differs depending on the type of works under consideration. So, for example, in the case of land, buildings, or any other structure, the statutory defect liability period extends for 5 years from the date of completion of the project. However, when the subject matter of the work that is done is made of either stone, limestone, brick, metal, or something similar material to that, the period is 10 years. So that's quite an extensive period of time. One important part, though, so bearing in mind that is obviously under the Korean Civil Act, so all contracts from that perspective would be under that. However, if the parties do, for example, decide to have the governing law being, let's say, Singaporean law, there would then not be the mandatory provision of that, because in terms of Article 7 of the Korean Act on Private International Law, these provisions would only be applicable when the governing law of the contract is Korean. So that could be a consideration for the parties to think about when drafting the contract, if they would want to avoid those type of liabilities for that extended period for 5 or 10 years. Then if we move over to the tender process, so I guess like most countries for public procurement contracts in Korea, these are concluded through tender processes. Generally, the open tender. There's also limited open tender options, selective tenders, or no bid procedures. But again, the open tenders are usually those that are most viable and followed sought after. Under the tender requirements, I mean, there's not a huge amount of legislation in terms of that. However, if you look at the public procurement laws, they stipulate that obviously public tenders should be executed between parties on equal footing. Each party is required to perform their contractual duties with good faith and bona fide good faith. Bidders and parties to public procurement contracts must also enter into an integrity pact, basically not stating that they won't provide illicit services or money or benefits for getting the contract. As mentioned, the tender process is awarded through an open tender, and any tenderer that is found to have been in breach in any of these regulations in terms of unlawful activities, etc., is subject to sanctions, which could also be a criminal sanction under the criminal code. So in essence, I think that's just a quick summary from a CRIM perspective, but it does seem like there's a lot of overlap between Korean and what I've heard from the other jurisdictions today. Thank you, Anil.
Brilliant. So just for the benefit, the system that you have is the civil law system as well, right?
Correct, Anil. We're civil law, so very similar to Japanese law, German law, French law, right?
Exactly. All right. So we get a sense that of similarities. Let's just move on to Shafiq. I'm going to add Shafiq in, and then I will take Tim off. Thanks, Tim. All right, here we go. And Shafiq, over to you.
All right, thanks, Anil. Yeah, hi everyone, I'm Shafiq here. Thanks for all the presentation and sharing. So I think from the Singapore perspective, even though I think Anil mentioned earlier that Singapore is a common law jurisdiction, I think, but Singapore also do have legislation that has been passed by the Singapore Parliament. So these are all essentially part of the Singapore law as well. And with respect to the building failure, what I'm focusing on today mainly is with respect to building collapse, or where there's incidents which led to the instability in the building structure, etc. So I think with respect to legislation on this, it can be found in the Building Control Act of Singapore. Actually, this act was enacted back in the late 1980s, following the collapse of the Hotel New World in Singapore. So under the Building Control Act, essentially what happens if there's they define it as a dangerous occurrences, which includes building collapse or structural instability. What happens is usually the commissioner for the building control will appoint an independent investigator to look into the causes for the dangerous occurrences, such as the building collapse or any structural instability. Then based on that, then essentially there are provisions in the Building Control Act which impose criminal liabilities on the various parties or personals that may be found at fault. And also under the Building Control Act, they also impose certain duties to certain parties. For example, the developers, they have a duty to appoint the appropriate qualified persons, engineers, consultants, to make sure that everything is done properly. And also for the Act also impose duties on the qualified persons to ensure that all the plans, submissions, calculations are all done in accordance to the various regulations that have been enacted in Singapore with respect to construction projects. And also I think Singapore, we have this accredited checkers. So these are essentially independent person who will check the detailed structural calculations and design calculations of the building before actually the building can be occupied by the public. Besides all this, so if any of these persons or parties actually breach any duties, and there are actually criminal sanctions imposed against them. For example, there are fines, some imprisonment terms as well. In terms of compensation for those people who are affected by the building failure, essentially these are all claims that are made under the common law. So it could be under contract or under Singapore, we have a law called tort law, which includes negligence. So for this kind of claims, usually you will need to prove that the person, basically you need to prove the fault before you can claim for the damages. Then moving on to the tender requirements in Singapore, essentially I think similar to most countries, the tender requirements, Singapore views public projects and private projects are slightly different. For public sector projects, the tender requirements are governed by an act called the Government Procurement Act. Actually, this act aims to give effect to the World Trade Organization Agreement on Government Procurement, which Singapore has acceded to. So, under this Government Procurement Act, so essentially it requires open tender, and all this the tender invitations for tender, the submissions, it's all done through an online government portal called the Government Electronic Business Portal, or in short, Singapore call it GBIZ, GEBIZ. So examples of public sector projects are, for example, the construction of the MRT lines, the HDB public housing, or public hospitals, etc. So it's actually any projects where the funds come from the government or the government agencies. However, for private sector projects, generally it really depends on the requirements of the procedures set up by the company themselves. So it's not mandated by law that for there to be any open tender. But sometimes some of these private projects also, especially for the bigger projects, they will do have an open tender, or for example, they have what they call a closed tender with pre-approved contractors. So sometimes they do have a list of contractors that they have previously worked with, and they just open this tender to that sort of like this closed contractors which they have pre-approved for the purposes of the tender. However, for like smaller construction projects, generally there's no tender process, and essentially anything the employer will just approach the desired contractor that they want to work with, and they will negotiate on the pricing. Yeah, that's about it, Anil. Thanks.
Thank you. I'm now going to get all of you back on. Let's see. Here we go. Here we go. Here we go. Here we go. And here we go. All right. Okay, so, oh yeah, myself would be a good idea, no? And me. All right. So, you know, for the benefit of our participants who may be here for the first time, you know, when we embarked on this series, the idea was for us to share and to see whether our experiences were different from certain aspects, and whether or not, if you're in a civil law country, you may be, you know, not as developed at certain jurisdictions, right? To consider whether or not the construction law and the principles are all similar, right? Now, interestingly, the first week we talked about two cases, one of which was a performance bond. And Shafiq, what was the other one? We had performance bond. Do you recall?
On defects.
Anyway, defects, all right? So we talked about case law. Adi had clearly, you know, set out and said, you know, in Indonesia, you don't really have case law as often as we have in Singapore, and as reported as much as reported. But we then went on to the workplace safety and health, so to speak, in Korea, right? And then when we shared among the different countries, you start to realize that the principles, the fundamental principles, are all similar, right? And the application of those principles are also kind of similar. And today we've had this great sharing by this team to showcase those aspects. Now, when we talked about the first topic, clearly you see that there is in some countries, correct me if I'm mistaken, and then please jump in. Adi and Tim, you have legislation in place, is that right? Tim, do you have legislation in place in Korea? You have the Civil Law 667 and 671, right? So those are legislations that are in place. Would that be right? Okay. So whereas in the other countries, there aren't really legislation in place when we're dealing with liability, right? And in those places, we fall back on what the law provides, right? So that's a good point. And then when we talk about tendering, it's also important to realize that all our countries here Indonesia, Vietnam, Cambodia, Korea, and Singapore. Issues about tendering are important. I know we didn't go down the path of crime and whether tenders are tainted and all those kind of things. But I was just wondering whether any of you had any views on that. So what I mean is this, for example, we have open tender, we have closed tender, and a specific tender for certain projects. And in my mind, that is mainly because you might have a project, say, for example, a pharmaceutical manufacturing plant, which is very specialized. So you can't have an open tender, right? But regardless of which tendering process it is, the issue of whether there's corruption and fault in the tendering, we do have a little bit about that, but that's not serious, right? Because it's managed well with the system that we have. So on that topic, I know we have about 4 minutes left. I'm just wondering whether any of you in your specific jurisdictions have faced problems as to, whether the tendering exercise is clean, whether a tendering exercise have had resulted in people being charged in criminal courts for offenses relating to how they tendered and whether it's legal or illegal. So anyone would like to start with that? Any of you face any of those things in your specific jurisdictions? Tim?
Anil, right. So as I mentioned, the procurement laws in CRID do make provision for avoiding of all of these. So if there's any sort of nefarious activity or the tender process has been, got through ways of corruption or money that's been pushed under the table, then you can imagine, many years ago, CRID obviously suffered quite heavily with the conglomerates that we have in terms of the power that they wield and their sort of bargaining power. To give an example, a couple of years back, probably 4 or 5, the Korean laws had changed in terms of when conglomerates are meeting for business lunches. There was even an act to induce to say that you can only spend up to $30 per lunch rather than having these lavish, $1,000, $2,000 lunches where they obviously trying to sort of get tenders and benefits from certain projects. So I think Korea from that perspective has tightened the range quite significantly. And to be honest, these days, there'll always be an element of corruption in any jurisdiction, but I'd say from a Korean perspective, it's pretty watertight and clean.
Cool.
We think the government's done well to tighten that up.
Yeah, thank you, Tim. I mean, you highlighted a good point about the fact that there was, the conglomerates, and then there was a problem before. So, quick points from any of you, the rest of you from the other countries, before we go to a quick question that for Adi and Astro. Wait, sure, where did the question go? Oh my God, there was a question. It's just now disappeared. No, okay, I still see it. Okay, so on the point that I talked about, corruption and problems with tendering, anybody else has got any other views? Yes? No?
Yeah, I think maybe just to add, I think
Yes, sir.
tender process is actually intended to minimize corruption, right? So there's no collusion, so all the appointment of constructor is through a due process lah. But I think in reality, I mean, if I'm not sure whether you heard, but one of the biggest construction state-owned entity is their director is currently being investigated for 2.5 IDR trillion corruption case.
Okay.
So yeah, fortunately, we see how it goes.
So on that point, right, you see, so sometimes it takes incidences like this for a system to be put in place. So for example, when Shafiq was talking about the building defects and the controls that were put in place, it arose out of a collapse of a hotel, right? So sometimes it does take those things. How about Huang and Vishal, anything else or from you on this point before we quickly go to the questions that's in the chat? Yes, no, gentlemen?
Yeah, for the case of Cambodia, we also have the law on public procurement actually set out some crimes related to the tender process. So in the case that there are corruptions or bribery, this case could subject to criminal responsibility. Yeah.
Thank you. Huang? No, right? When you unmuted, I don't know what happened, but we couldn't hear. So, quick question for Adi, if you could. By the way, there was a question about whether the slides will be made available. Although the slides for all our series is going to be made available, so do please come on board and let us know, and we will send you the slides. Okay, so the question there is this, Adi and Astro, suppose the project is funded by an international grant for public interest development, such as wastewater sector projects. Is the 2017 construction law applied, or use of international law where the country provides the grant? Now, before you answer that, we are now at 4 p.m. We should end, so I'm just asking permission if you all could just, give us another 5 minutes. Those of you who are able to stay on with us and let Adi answer this question. Adi, over to you.
Yeah, I think I'll just answer it quickly. It depends on the how the whole grant is structured, right? For example, if it's a G2G grant, which has to be distributed by the government for example, government of for example, ADB give the grants to Indonesian government, and Indonesian government has to kind of pass through the loan to contractors, then it will fall under the public procurement requirement. But if it, for example, ADB gives the grants directly to the developer, then it depends on the sector. I understand that the sector that is being questioned is the wastewater sector. I don't think wastewater sector is. Oh yeah, so irrigation, sewage, and sanitation is one of the public sector that has to be conducted through a tender. However, as Asta has mentioned, the law is silent on how the tender is supposed to be, how the selection process is to be conducted. So there's no, unlike for public procurement, for public interest, there's no specific procedures that is required by the law. So you can follow, for typically the banks or the lenders have their own requirement. Yeah.
Okay, so thank you so much for this. There are no other questions there. So one final point, the slides from Adi and Astro will be made available. Shafiq's material will also be put up on the slides, but we just need a couple of days, so it will be made available. So those of you who would like that, and from our past series as well, please do reach out to us, and we will send it to you. Thank you very much. Next week we move to our last of the season series. In this series, Vietnam and Cambodia. So please do look out for it. And anybody who wants to reach out to us, please reach out to us, and we'll take it from there. Thank you very much. Have a great rest of the week. Bye.